Hello friends, Mandar here. I'm back with another video. Happy New Year 2024. Today we'll take a look at the policy guidance on employers' ability to pay that has been given by USCIS. It just came in last week and we'll take a look at it. It has created some obvious questions that we'll try to address. We'll also take a look at how many visa numbers will USCIS process in the EB category, what has they written in the Q&A section, and how USCIS is also promoting O1 visa for the people who have been stuck in the employment-based backlog. And there is also another topic on open work permit for Canada and some questions related to that. So a lot of packed content, guys. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Check out the links in the description because those are affiliate links and you might find something interesting in it, and that will also help the channel. And while you are down there, do hit the like button. Comment about the topics that you would want me to cover in my future videos because that's where I get most of my ideas for my videos. Also do follow me on Twitter and Instagram because I also do post some updates over there. Now let's start with our first topic of the day. USCIS has issued a policy guidance on ability to pay requirements when adjustment of status applications change employers. Now this is very particular and this has raised some concerns with people, and I'll talk to you about that. Now let's look at actual policy guidance. I'm directly going to take a look at this policy guidance. So the policy alert was issued on January 5th, 2024. What it says is establishing an employer's ability to pay the preferred wage for certain employment-based immigrant visa petitions. So the purpose of this is USCIS is issuing a policy guidance to address the analysis of employers' ability to pay for preferred wage for certain EB categories of visa. Now let's look at what it exactly says. It's not too long, so I'm just going to read it out and then we'll discuss about it. Background is employers seeking to classify prospective EB1, EB2 or EB3 that requires job offer must demonstrate their continuing ability to pay the preferred wages to the beneficiary as of the priority date of the migrant visa petition until beneficiary obtains the lawful permanent residence. So this is the current guidance. What USCIS currently asks is they need the employer to demonstrate the ability to pay the salary that was as of the priority date of the petitioner. So say for instance your priority date is January of 2014. Now what USCIS will do is they will ask for ability to pay going back to that priority date until you get your green card. That could be a lot of number of years. Now the relevant regulation requires employers to submit annual reports, financial tax information and so on for each available year from the priority date. This is key. So imagine if there are smaller employers or say Indian consulting agencies, they will be required to present the financial information from the priority date of the individual until they get the green card. So it could be several years worth of financial information that these small companies will have to provide to USCIS. Now if the employer has 100 or more workers, then it may be instead include a financial officer's statement attesting to the petitioner's ability to pay the preferred wage. So in case they have more than 100 petitioners, then their CFO or financial officer can just make a statement that they are able to pay all of these employers. So they are putting that burden on that financial officer of that company to make a statement in lieu of providing all the evidences. Now USCIS is updating its guidance to explain that where the beneficiary has ported to a new employer under the AC21 rule and the immigrant petition of the alien workers is pending, the officer determine ability to pay by only reviewing the facts in existence from the priority date until the filing of I-140. USCIS is also making other minor technical revisions to improve clarity and readability and otherwise streamline existing guidance. The policy highlights that it explains when the beneficiary of I-140 ports to a new employer under AC21 while I-140 is pending, USCIS determines whether the petitioner meets the ability to pay by only reviewing the facts in existence from the priority date to the time of filing. Now this is a very specific situation. I'm going to tell you and I'm going to describe to you about it. Now let's consider currently they want the employer to provide in financial information for all the years from the priority date of the beneficiary until they get the green card. That is what they currently require. So this is a lot of documentation. So people from backlog countries obviously are going to be in this for many number of years, say 10 or 12 years since their priority date. So if their priority date was say 2012 December, if they get a green card is 2024, it's that many number of years that the petitioner will have to provide the financial information in order to prove that they have the ability to pay. So what this policy guidance is saying is that in the event that the beneficiary of I-140 changes job using AC21 rule, then they will only ask for the financial information from the priority date until the petition is filed, I-140 petition is filed. So which may be very small duration, because usually the priority date is set when you submit your perm petition or labor certification. That's where your priority date is fixed. So maybe it takes a year for the perm to process and then you apply for I-140. So it's only 1.5 years of financial information that USCIS is going to ask. But this is very specific situation. So many people asked me, why would anyone change a job while their I-140 is pending, and how can they use an AC21 rule while their I-140 is pending? Now let me tell you, this is a unique scenario where your priority date is current, and because of that you are able to concurrently file your I-140 and 485 at the same time to avail this AC21 rule. So say for instance you are in EB1 category or rest of the world where your category is current and you apply for I-140 and 485 at the same time. What happens is, even if you fulfill the conditions for AC21 by having waited 180 days on pending I-485, your I-140 may still be pending because you did not file in premium processing. So in that scenario, what USCIS is saying, if the petitioner changes the job using AC21 based on having waited for 180 days on pending I-485, even though their I-140 petition is not approved, in that specific scenario, they will only ask the employer to submit the financial information from the priority date until the I-140 petition was filed. So hope that is clear. Now the question remains, who would change a job when their I-140 is pending? Now the only scenario that I can think of, if you lose the job. So say for instance you have applied for I-140 in the regular processing and I-485 concurrently, you have waited for 180 days, that qualifies you for AC21 job portability, but your I-140 has not approved and you got laid off. In that situation you have no option but to change the employer. In this situation, although it is risky, you have no choice. But if you don't lose a job, if you have waited on pending I-485 for 180 days or more, and if your I-140 is not yet approved, I would never recommend to change a job. You should always wait for your I-140 to be approved before switching the employer, even though you can use AC21 rule. The reason is, technically your employer can revoke your I-140. And once they revoke your I-140, there are challenges getting your green card approved. So what happens if you get an RFE on your I-140 which is still pending and you leave your job? The employer has no incentive to respond to that RFE because you are not working for them. Your application may get rejected and you would be sitting on an pending I-485 without an approved I-140. That will be a bad situation. So even though this letter is vague, it says pending I-140 people can still change job. It is a very specific scenario in my opinion where your priority date is current, but you should still wait for your I-140 to be approved before using AC21 to change a job. So that is my opinion. Let me know in the comment section below if there are any other questions that you have in this particular situation. Again, to repeat, the risk in here is if your I-140 is not approved, there is a chance that USCIS may issue you an RFE and employer will not respond to that RFE and you may get an NOID, which is Notice of Intent to Deny. I-140, and that is not what you want before changing your job. You want your I-140 to be approved. You have waited for 180 days after the approval, and then is the time to change your job, so that even if the petition or I-140 is revoked by the previous employer, it will not matter and you will still have your priority date and your approved I-140. Do contact me if you have more questions on this, or put them in the comment section below, and I will try to cover them in my next video. Now another thing to remember here is, once you change the job using AC21, make sure that your new employer files for I-485J, Supplement J. That will prove the USCIS that you have, although you have changed the job, it is in the same category or similar category as that was mentioned in your approved I-140 or pending I-140. That is just my suggestion. Now another question is, there was an update on, can you estimate how many employment based immigrant visas USCIS or DOS will use during the FY 2024? Now this is a common question and it comes towards the end of the year, but let's read through it what the USCIS has said, so that you can get an idea whether there will be any spillovers or whether there will be any visas wasted. So DOS currently estimates that the FY24 employment based annual limit will be approximately 161,000. We already know that because of the spillovers due to unused family sponsored numbers from FY23. In addition to the 161 overall limit, in the EB5 category there are 10,000 extra visas available that Congress has allowed to carry forward from the previous fiscal year. So EB5 in 2022 was underutilized, so there are extra 10,000 visas that were added to the pool for FY24 in EB category. Now those visas go to EB1 first, then if they are not any unused, go to EB2 and EB3 and so on. That's the cycle that USCIS uses for extra visas coming from EB5. Now what they say is, our immigration and citizenship data quarterly reports do not provide a comprehensive picture of employment based visa use. So the numbers that they publish every quarter, they are saying that they don't represent the exact use. The quarterly reports do not include the visas issued at our partners, so DOS. They are putting a disclaimer that none of those reports can be used to determine the number of employment based immigrant visas used during that quarter. So they are saying that don't use those numbers for doing any kind of predictions. That tells the level of confidence that USCIS has in publishing those numbers, because those numbers are not complete. They don't have those DOS related visa issuance numbers in those quarterly numbers. So any prediction anybody is making, take them with a grain of salt. That's what I would say. Now the next one that I wanted to show is, USCIS is promoting O1 visa. So I know for sure that some of you are interested in stock trading, day trading, buying cryptocurrencies. I want to present you Webull. Webull is a trading platform. It allows you to buy stock, it allows you to buy options, do options trading, and also it allows you to buy cryptocurrency. Webull 9 was released with a brand new home and market page, asset page and economic calendar. Also Webull cash management was launched with 5.8% API with no fees attached and no minimum balance and unlimited withdrawals. This is amazing. New Webull USA users can still enjoy 5.8% APY and get up to 12 free stocks when making an initial deposit of each is valued between $3 and $3,000. Feel free to take advantage of this. Join through my link and you will get those free stocks. The USCIS is actively promoting the O1 visa on their Twitter handle. This is the Twitter feed that I came across, and I just thought I would mention that to people in the backlog. So USCIS made this announcement for O1 visa individuals with extraordinary ability or achievements. So I wanted to point this out because this may be useful for people who are waiting for a long time for their employment based visas, especially from the backlog countries. Now people who are contemplating applying in EB5 or EB1A, you might also want to consider O1 visa category. Now O1 is for extraordinary ability or achievements, and it is also a dual intent visa because it will also allow you to apply for a green card. The O1 non-immigrant visa is for individuals who possess extraordinary ability in science, arts, education, business, athletics, or who has demonstrated a record of extraordinary achievement in the motion picture or television industry and has been recognized nationally or internationally for those achievements. So especially for people who are working in STEM, science, engineering, technology and maths, they should look at this particular visa as well, in addition to all other categories that you are already looking at. The eligibility for this visa is very clear. It doesn't, mind you, this is a non-immigrant visa. It will not get you green card directly, but it will put you on the path for the green card. The reason is the requirements are so similar for EB1A. It's like L1A. Once you have the L1A of international managers, you mostly qualify for EB1C. Using the same logic, if you qualify for O1 visa, that already proves that you have extraordinary capability and you can qualify for EB1A. So it's a natural progression to go from O1 to EB1A or EB1B. If you need more information on this, do contact me on my Calendly. I'll be happy to provide my thoughts in your particular situation. A lot of people have been contacting me on EB5 and EB1A. The reason I am able to talk to it is because I have first-hand information from people who have successfully done their EB5 and EB1A. That's the experience that I can share with you, and I can tell you how you should apply, what is the right strategy, and what are the pitfalls to avoid when you are applying for EB5 or EB1A. So do reach out to me if you need to talk to me. And the last point I wanted to cover in this video is people who are contemplating moving to Canada on open work permit. Recently I have come to know that even though this program for H1b related open work permit for Canada was done back in September and approvals were given soon after, some people are still getting their approvals even now. And then the only logical explanation to that is they did not get enough applicants who actually moved to Canada, so they are issuing more number of visas in that particular category. So people who have been waiting and never heard back from IRCC regarding their outcome of their open work permit can expect to see a positive outcome even now. Now when you go to Canada in the intent of getting this 1 year managerial experience working from Canada, you need to make sure that you are working for Canadian entity. You cannot just keep working for US entity and go to Canada and expect to be qualified for EB1C. That will not happen. You will have to work for non-US entity in the managerial position for at least 1 year in the last 3 years to be able to qualify for EB1C. So that is one important note. And when you do so, if you have family here in the US who is on H4, they will need to travel with you to live with you in Canada while you are fulfilling this obligation. The reason is they cannot be living in the US on H4 because technically when you leave the US and take up an employment in the outside, there is no underlying H1 to support their H4 petition. So they could fall out of status. So you need to take them along with you when you go to Canada. Just some pitfalls to avoid in this particular situation. And starting February 26th, there is going to be a fee increase for premium processing. I have a detailed video made in my last video. Do check that video out if you haven't already. So that's really all I wanted to say in this video. If you like the content of this video, hit the like button and consider subscribing to my channel. And I'll see you in the next one.